my self-introduction. My name is Michael. I'm the moderator for today's. I'd like to give floor to Professor Boris. He's from Netherlands, the first country in the world to recognize the same-sex couple marriage.
Well, Michael, thank you so much for having me. It's really my honor to be in your presence and to talk a little bit about two things, actually. First, I would like to give let's say, an overview about the Dutch same-sex marriage law and the history a little bit. And then I will focus on parental rights, because that's actually the topic of today's meeting. But now let me go back to the 1st of April, but then 20 years ago. I think the significance of same-sex marriage in the Netherlands is that there is now a whole generation in the Netherlands of young people who grew up with the idea that love defines a marriage and not the gender of the two partners. So it doesn't matter if it's a man and a woman who are married, or two men or two women. There's this whole generation of young people who find it completely unthinkable that there used to be discrimination against same-sex couples in terms of marriage rights. Let me go back to the 90s in the Netherlands. There were a lot of debates about equal rights of lesbian, gay, and bisexual people, not so much transgender people, because in the 90s, so let's say 30 years ago, transgender people were relatively invisible in Dutch society. So it was more about gay rights. And there was a lot of debate because in the 80s, we were confronted with AIDS, and a lot of young gay men died because of AIDS. And at the time, I was a lawyer in Amsterdam, and I defended several of the surviving partners of young men who died from AIDS. And I noticed that they didn't have any rights. So it was very easy for the landlord to evict the surviving partner, or for parents of the son who died to say, you have to leave the house within a few hours, and all the stuff that's in the house is ours because we as parents inherit all the things that our late son has left. And so that was very unfair. And I thought at the time when I was a lawyer, I thought, when I will be a politician, I really need to do something about that. And so in 1994, I was elected for the first time as member of parliament. And during my campaign, which started in 1993, I was open about my sexual orientation. And I told the Dutch public that if they would vote for me, I would really try to come up with solutions about the fact that gay couples, lesbian couples didn't have any rights. And so I was elected. And in 1994, I proposed for the first time same-sex marriage in Dutch parliament. And this was a very far-fetched idea, actually, because nowhere in the world same-sex marriages took place. So most people said to me, yeah, but it doesn't exist anywhere, so why would we want to be the first? And it was very difficult because the Dutch LGBT movement came to me and said, we are so disappointed in you, because now finally we have the first openly gay member of parliament who is talking about family rights, who is a lawyer and who could do stuff for us. And now he wants to open marriage, civil marriage to same-sex couples. They said, that's not what we want, because we see marriage as an old-fashioned heteronormative institution which suppresses our lifestyle. And so they said to me, please focus on other issues. We don't support you. And that, of course, was very difficult for me, because a lot of other members of parliament said, well, if your own community doesn't support same-sex marriage, why would we support it? So it was kind of difficult. But after I would say 1 or 2 years, they changed course, and a new board of the NGO, the LGBT NGO, came forward, and they said, okay, we will support you. Well, to make a long story short, in 1998, we started first with registered partnership, because at the time we still thought that same-sex marriage would not be feasible, but we wanted to grant legal rights to same-sex couples. So we started with a registered partnership law, which is in effect almost the same as same-sex marriage, except that, of course, the name is different. And when you divorce, there's a big difference. A marriage, when you divorce, you have to go, in the Netherlands, you have to go to the court and you have to ask the judge to dissolve your marriage. But when you have a registered partnership, you simply go to the municipality, to an official, and you declare that you want to break up your relationship, your registered partnership, and that's it. So there was this difference. And so the interesting thing was that when we introduced registered partnership in 1998, a lot of gay and lesbian couples went to the municipality to have their relationship registered, but they didn't really know the difference between marriage or registered partnership. So when they went to the municipality with their parents and friends and family members, they came out and they said, yes, we're married, we're married. Of course, that was not the case, but it really helped the Dutch public, the general public, to accept the fact that it's about love, marriage, and it's not about the gender of the two partners. And so in 2001, we introduced marriage equality. I can talk a little bit more about that in detail, but let me skip that for now. But if there are questions about how it came about, then I can talk a little bit more about that. I should really emphasize that although we now have a marriage law, and the law is actually very simple, it, in our family law, it now says a marriage consists of two partners, could be opposite sex partners or same-sex partners. And for the rest, the marriage legislation stayed the same as it was before. So it was just a matter of fixing a few words in the family code of our civil code. But what I wanted to say is that it's of course wonderful that we achieved this 20 years ago in 2001 when the first marriages took place, but it doesn't mean that discrimination in society against gays, lesbians, bisexual people, transgender people have stopped. No, it's not the case. Unfortunately, there are still a lot of issues also in the Netherlands that we need to solve. We have this very active LGBT community. There's this NGO, and last week we had our elections in the Netherlands, our national elections again. And this NGO was very active. So a few weeks before the elections, they drafted a list of things they wanted to achieve, and they invited all major political parties to come to this meeting and to sign a document in which those political parties propose to solve these issues that are still at hand and to come up with new legislation in order to strive for full equality without discrimination. There are a few things on the list which are interesting, and then I will start focusing on parenthood. But on the list, it says, for instance, that everybody in the Netherlands will be allowed to have the marker X in his or her passport instead of male or female. So you don't have to be categorized as male or female anymore, just an X in the passport or other identification documents will be enough. And also the political parties who signed on to this list, this wish list of the LGBT movement, they said we will strive to eliminate asking somebody's gender in official documents if it's not necessary for instance, medical reasons. Of course, sometimes when there is a public survey and the government wants to know if women might be prone to develop breast cancer, of course, then it's important to ask a person, are you male or female? But in a lot of cases, like if you want to have a driver's license, it's not relevant to know if you are male or female. So the political parties now promised to start drafting legislation. But there are many other topics on the wish list that these major political parties signed on. In the Netherlands, we have many political parties, and usually 3 or 4 political parties will form a coalition government. And the idea is that this wish list will end up in the coalition contract. There's one issue that I would like to highlight now on this wish list, and that's the focus on rainbow families. Like, for instance, Didi's story we heard in the beginning, that would be very relevant. According to the Dutch definition, a rainbow family can consist of 2 women or 2 men, or a combination of 2 couples, women and female or male couples, who are raising 1 or more children. In the Netherlands, we have 17 million inhabitants, and we don't know how many rainbow families there are. This is not registered, so it's a little bit difficult, but according to NGOs whom I contacted, one estimates there are about 10,000 or even more rainbow families at present. So this combination of parents who are raising children. Up until now, according to Dutch law, a child can only have 2 legal parents. Usually, of course, that's a father and a mother, but we make a distinction in Dutch law between legal parenthood and custody rights. According to Dutch law, a child can have a maximum of 2 legal parents and 2 parents with custody rights. Often this is the case, for instance, when a divorce has taken place and when one of the legal parents remarries or has a registered partnership with a new partner, and then the new partner can obtain custody rights. In situations of 2 women who are married, the birth mother will always be the legal parent according to Dutch legislation, and her wife can obtain legal parenthood only in the situation if there is no biological father in sight. For instance, if there is an anonymous donor, sperm donor involved, or the women say they don't know who the father is. If the donor is a family friend, the other mother can only obtain custody rights, so no legal parenthood, unless, there are always exceptions of course, unless the biological father does not object against the second mother becoming legal parent, and then they need to sign a document, and then the child can have 2 legal mothers. When there are more grown-ups involved in raising children, like a lesbian couple and a gay couple, and this happens quite often, and I know from my own experience. There are in my vicinity lesbian and gay couples raising one or more children. So it's 4 adults. Then the legal situation becomes, of course, complex because there are some legal and financial problems at the moment, according to Dutch legislation. Let me mention a few. Medical issues, for instance, when you are the 3rd or the 4th parent, you are not allowed to visit a doctor with your child, and you cannot grant permission for a medical procedure in relation to your child, and you don't have access to the medical records of the child. This when you are the 3rd or the 4th parent. In educational matters, there are schools who do not allow the 3rd or 4th parent to come to the school and get information about how the child is doing at school in information meetings, especially designed for parents. In terms of travel, there are problems. You're not allowed to request a new passport for your child when you are the 3rd or 4th parent. You're not allowed to take the child across the border to another country. And especially in a situation of a conflict, like what Didi was mentioning in the introduction, you could even run the risk of being accused of child's abduction if you take the child across the border without permission of the 1st or 2nd parent. In terms of finances, there are difficulties. For instance, a child has to pay more taxes when the child inherits from the 3rd or 4th parent, and that's different from when it inherits from the 1st or 2nd parent. So in taxes, there is still a difference that needs to be solved. And a 3rd or 4th parent is not allowed to open a savings bank account for the child formally. And last example I would like to give is when the legal parents die, for instance, in a car accident, the 1st and 2nd parent die, the 3rd and 4th parent, who are also raising the child, they do not get automatically a legal parenthood, but it's a court, a judge, who has to decide what's the best interest of the child. And of course, one can assume it would be to grant legal parenthood to the 3rd and 4th parent, but there are cases when there are conflicts in families that grandparents, for instance, say, no, we now want to have legal parenthood. And then, you know, there's this whole difficult thing in a court case. Now, to try to fix these problems, I just mentioned a few of the main problems that 3rd or 4th parents are confronted with. The Dutch Parliament asked the government to install a state commission on what they call modern family law. And the state commission was installed in 2016. In 2017, they came with a report. And in their report, they have a few suggestions for the government and for the Dutch Parliament how to renew Dutch family legislation. And I would like to mention a few of these examples. But before I start, I'm looking at Michael, and I'm asking Michael, how much time do I have left? I don't hear you.
Sorry, I muted myself. I think you can finish the examples you're about to give us, and we can move to the question.
Yes. Okay, so I will make it relatively short. The State Committee, and it's a very important commission, they said every legislation that we are about to introduce should be viewed in the best interest of the child. So it shouldn't be an emancipatory movement. No, we are looking what is best for a child that's being raised by multiple parents, for instance. And from that perspective, we are proposing some changes. The most important change, I would say, would be that biological parental descent should be on equal footing intentional parenthood. So the biological parent and the parent who wants to raise the child, but who's not the biological parent, they should have the same rights in relation to the child. If there are more than two parents, for instance, a gay couple raising a child with a lesbian couple or one lesbian mother, they could all three or four become the legal parent of the child, but under the condition that all four parents, so the gay couple and the lesbian couple, they should agree and have their agreement documented. If there is not such an agreement, there can be no multi-parenthood, according to this proposal by the Dutch State Commission. And the agreement must be made before the child is born. So it requires a lot of, let's say, knowledge of the future parents when they decide to make a child and to bring a child into the world. They must realize that they have to arrange a lot of things before the child is born. And their arrangements have to be documented in a contract, and the contract should be approved by a judge. So it's a serious business if you want to have a child raised by two couples, for instance. You really have to think and plan ahead and go to the court and get approval. This all according to the suggestions of the Dutch committee. And a hotly debated topic, and I noticed this already, that's a reality on the ground. If a child is born in such a combination, one of the most hotly debated topics is which last name will the child get? Because usually all the parents want their last name to give to the child, and so that's complicated. And so the State Commission proposes that the parents, before the child is born, have to choose one last name. And if other children are born in this combination, all children will have the same last name as they chose for the first child. And it should be documented. And that's, of course, complicated. So it's very important that future parents will have good, solid information by the government what to do if you want to bring a child into the world, into such a relationship. So let me now conclude by saying that the Dutch State Commission, but also we as members of parliament, we are always in close contact with Dutch NGOs, with civil society, because of course that's where the personal stories take place, like Didi's story and her problems. And they are very important for us as members of parliament to listen to these personalized stories and to think, how can we come up with solutions? So in the Dutch democracy, it really works well that politicians, the government, the State Commission, members of parliament work together with national NGOs in order to solve these problems. I would like to say that in Dutch democracy, it's very important if you have a vision, if you know what you want, if you want to solve these problems, you have to try to make your dreams come true. Sometimes it works, sometimes you win, and of course, in politics, sometimes you lose. That's all part of the game. But we should always remember that the future is not in front of us, but the future is inside of us. And each one of us can make his or her dreams come true. Thank you very much. Second question is about registered partnership and then marriage. What I try to explain is that because nowhere in the world same-sex marriage existed in the 90s, and because there was a lot of opposition against my idea when I proposed it in Parliament, I thought it would be cleverer first to start with registered partnership, and that's what we did. People got used to registered partnership, and then the step towards full equal marriage rights, exactly the same rights as to opposite partners or to same-sex partners can have. That step was easier to take. And there is not so much difference in terms of legal consequences between registered partnership and marriage. So in our Dutch system, we have registered partnership. You can choose if you don't want to get married. It's open to same-sex couples, but also to opposite-sex couples. So everybody can choose that, or you can choose marriage. It's also open to opposite and same-sex couples. Once you have chosen registered partnership, it sometimes happens that people, after a few years, say, actually, we want to get married. And then it's very simple to change your registered partnership into an official marriage. So there are hardly any problems with those two. Interestingly enough, the registered partnership is more popular under opposite sex couples than same-sex couples. So same-sex couples, when they want to officially their relationship being recognized, they prefer to go to a marriage, to marry. And opposite sex couples tend to go to registered partnership, which is interesting. In terms of the rights towards children, it doesn't really make a difference. Adoption is in a separate law granted to single parents, but also to couples. And it doesn't make a difference if it's two men, two women, or a man and a woman. But we have to understand that there are only maybe 200-300 children per year who are born in the Netherlands who are up for adoption. Most adoption cases are children born in China, for instance, or Colombia or Brazil, who are adopted by Dutch parents and have to come to the Netherlands. And of course, it's the adoption authority in the country of origin who can decide whether they want to give their child up for adoption to a gay couple or a lesbian couple. Sometimes there are countries abroad who say, no, we don't want two men or two women to raise a child that is born in our country. And so there is no Dutch jurisdiction, of course, over such an adoption authority in a country of origin. So in terms of reproduction rights, there is no discrimination against, let's say, lesbian women. They have the same rights in order to get sperm donations, for instance, from a sperm bank or IVF procedure. There is no difference between a woman married to a man or, for instance, married to another woman. In the beginning, the Dutch LGBT community was not in favor of my proposal to introduce same-sex marriage because they said we have a different lifestyle and our lifestyle is different from heterosexual couples. So why would we imitate them just focus on other issues. But of course, in society, and also in my book, and this one chapter has been translated, there were lots of gay couples and lesbian couples who did want to get marriage rights, equal marriage rights. And so you could actually see a difference that in society, people came to me and said, please go forward and try to achieve same-sex marriage, while the board of the LGBT group, NGO, said, no, we don't want it. And so there was a discussion within the NGO community, in the NGO, and then the board was changed and younger people were elected in the board of the LGBT group. And they said, yes, we do want marriage rights because we want to be treated equally like everybody else. And then once there is same-sex marriage, we can always say, we don't want to get married, but we must have the same choice as others. And in this process, I work together with role models. So I noticed that Michael, in his introduction, mentioned a famous singer in China who was gay and who died on the 1st of April. So for me, at the time, 25 years ago, 1995, 1996, when this was really debated in society and parliament, I looked for role models, and it could be scientists, it could be lawyers, it could be parents and friends of LGBT people, it could be actors or singers or sports people. And I asked several of them, and some of them were straight allies, they were heterosexual, but they thought it would be important to have equal marriage rights for LGBT people. And so I asked them to speak up and to join forces. And together with those allies, it really became a movement, and everybody was talking about it in the 90s. And so a lot of people who didn't really care about same-sex marriage, they thought, well, but what I do care about is that LGBT people are treated equally without discrimination. Also, not discriminatory laws should be there. And so that had been very important for the public discourse, to have straight allies supporting the case of same-sex marriage.
Thank you, Boris. As we said, prior to this event, we're very glad to have translated Boris' memoir into Chinese. We thank 何谓自由 Libertarius Digest Helan for this work, and translator Xiaodan, Zhang and Susie for their work to translate this chapter to Chinese. It's a very good book, and we have already circulated the link of this translation of today's. Since Boris needs to be leaving us soon, I want to ask if there is any final question from Professor Yang to Boris for his remarks. 杨老师，杨教授，您有一些给 Boris 的这个问题吗？他待会儿
Professor Yang, do you have any question for Boris? Because Boris has to leave earlier for another meeting. No question from me, and thanks a lot to Boris for his sharing.
Thank you, Boris. Thank you, Boris. Once again, thank you very much for joining us, and hopefully we can really have you physically with us in mainland China and also in Hong Kong in the future.
Thank you very much.
Thank you, Boris.
Bye-bye.
好，今天我们活动的上半场结束，感谢
Well, this would be the conclusion of our first session, and thanks a lot to Boris. In our second session, would focus on the situation in China. Boris mentioned that in the promotion of the rights of LGBT, NGO plays a very important role, and according to Didi's story, we can see that there are a lot of room for us to improve in the relevant rights and interests. And I like to give floor to a lawyer, Dong Xiaoying, who's the advocate for diverse family network. So yeah, I'm here. Can you hear me? Yes. So my name is Dong Xiaoying. I'm from Advocates for Diverse Family Network. As Michael introduced, we focus on the rights of singles and the lesbians and their reproductive rights and the relevant status. And I will introduce the situation of the relevant communities. And thanks a lot for the invitation from University of Hong Kong. I will share my screen with you. The first part is about the lesbians. You know that lesbians are forced to be single, and their reproductive rights are not protected by the same-sex marriage because we didn't have the relevant rules of same-sex marriage. And you know, in China, the reproductive rights are related to the marriage, and because in China, we didn't have the relevant recognition about same-sex marriage, their reproductive rights are not protected. And in 2016, we had the relevant research and found several difficulties. First is about difficulty of pregnancy. According to the rules and laws from Ministry of Health, it's prohibited to help the single women or other people who are not recognized by the law. As a result, the reproductive rights of singles and lesbians are not protected. And you know that the prohibition of implementation of human reproductive technology, including the sperm bank or the IVF and so on, are prohibited. And in 2003, the Ministry of Health had the Code of Practice for Assisted Human Reproductive Techniques. It mentioned that the artificial assisted reproductive technology is a way or is a treatment for infertility instead of a resort for the singles or the lesbians. And there are a lot of discussion about reproductive rights. And in the 2 sessions this year, there are several proposals about the promotion of reproductive rights for singles. And maybe in the future, we could see some lights in this regard. Those lesbians in the future may be entitled to using those technologies to get pregnant. And we've made some research and survey for the sperm banks across the country. By the year of 2019, the 23 sperm banks, they cannot provide sperm application services for single women, but for a woman, if you want to get married or get pregnant, you need to have the sperm. So in China, you couldn't realize the pregnancy through the sperm donation. You can just go outside the country, like Didi, they went to the US. And there's a special case in Jilin province in 2004. It said that women who have reached the legal age of marriage and decide not to marry and have no children can adopt legally medical assisted reproductive technology to give birth to a child. This is a good news for the singles and the relevant group. We went to 4 hospitals with IVF service. But you know that back in 2016, the application was denied because they claimed that the applicant was not married. She was a single lady, so they denied her application. So though there's the relevant rules in place, actually the hospitals or the institutions still denied such application. Because you know that our country does not encourage the pregnancy at single state. And in 2018, we had the advocacy during the NPC and the CPPCC, Jilin province is actually very advanced in the relevant regulation, and we hope that this kind of cases could be advocated and expanded. And at that time, the relevant authority gave some response for single women to get married. There should be 5 prerequisites. First, the household registration is within the province. Second, they have no kids. Third, they decided not to marry in the lifetime, or they have got married and decided not to get married again. Fourth, it's out of their own willingness. Fifth, they have no relevant diseases in reproduction. We've done a lot to promote the relevant legislation. So the regulations are there, but it's not fully used. And even the single women got pregnant and gave birth to a baby, there will be difficulties after their children were born. First of all, is the children's household registration problem. Second is about the alimony or the social maintenance fee. Though the law promulgated that the relevant fee should be paid, but in practice, it's not actually implemented. The third is about our theme today. It's about the parental rights. Because the partnership or the marriage were not recognized by the law, child can only have one legal parent-child relationship with one mother. And the fourth difficulty is about maternity insurance. Those single mothers, they couldn't enjoy the equal maternity insurance, but there are 2 exceptions in Guangdong and Shanghai. They have some openings in the law about the maternity for single mother or the lesbian mother. And the fifth is about the difficulties in employment, especially for those who are in public sectors. They may be dismissed or get some disciplined punishment and so on. And also about the question on parental rights. We believe in the past that who gave birth to the baby will be the mother for the baby. But now sometimes the kids may be registered in the name of the other one in the couple. And the second is about our preliminary sharing of community survey results. In 2 months from August to October in 2020, we have 2,900 valid questionnaires for the lesbians or the relevant community. We actually made some survey about their reproductive rights, and about 59.2% of the people had the plan or had already planned to live with a same-sex partner in China and did not legally marry another opposite sex. You can see that the number is quite high, standing at 638. And also 185 or 73.4 people help to have sperm through foreign legal artificial assisted reproductive technology, like the practice by Didi and her partner. You know that in China, it's not legal, so they chose to go abroad. And about the reproduction of the delivery, usually they will have the ovum from A, and B will be the one who got pregnant. So about 30% of the people chose to have this method. But all this kind of practice would resort to artificial assisted reproductive technology. And in China, you know that it's very strict, and you couldn't implement this technology, so you need to go abroad to have the relevant help. But in China, after you return to China, sometimes the status wouldn't be recognized. And also, we asked question about the difficulties during their pregnancy and before and after the childbirth. Actually, there are a lot of difficulties. About 20% of the people couldn't enjoy the maternity insurance, which is quite important for them. You know that for lesbian couple, even though you are not going outside of the box, it's actually a very great burden for you without the insurance, and also some discrimination or prejudice from the employment is also a very large difficulty. And also the sperm donor, they couldn't totally be separated from the kids. And it's also a problem for the lesbian couple. So in China, even though you succeed to get a donor, sperm donor, or you married an opposite sex, it's also a difficulty for them to have a very clear relationship. And a lot of people, they are not worried about certain kind of things we thought is a problem. And also about the female reproductive rights. A lot of person, we asked whether they are willing to resort to the relevant legal activities like the intended guardianship, entrusted guardianship, and so on. If you look at the tripartites, 71% of them are totally willing to do something to protect their own rights. And during our survey, we found that some of them already made their effort. And we are also spreading the story to tell this group of people that they can have some choice. And the third is about case sharing. So sorry, we are running out of time. And the third is a case study. It's about the ovum from A and B is the one who got pregnancy. And you know that they got the technology in China and gave birth to a pigeon pair. But it's in violation of the law in China, so there's no relevant evidence. And after they break up, one wants to get the custody of the kids, but it's very difficult for her because there's no evidence and the court wouldn't claim it as a case. So there's no option but to give up. It's really a pity. And also about some of the prospects for the reproductive technologies in China during the NPC and the CPPCC. Actually, a member of the CPPCC mentioned that we need to loosen some restriction in this regard so as to guarantee the reproductive rights of single women in China. That's a conclusion of my sharing. Thank you. So thanks a lot to Xiaoying and your sharing about the advocates in the diversified family network, and we've witnessed your practice and efforts in the promotion of the relevant rights. And next, I'd like to give floor to Professor Yang. Professor Yang is from China's Renmin University of China, from the law school, and the adjunct professor at National Prosecutors College. And he is also the child team leader of the Civil Division of the Supreme People's Court, and he's involved in the drafting and amendment of many laws, including the contract law, the property law, the tort liability law, and the civil code. And today, Professor Yang will share with us on the theme, respecting the dignity of children born with artificial assisted reproductive technology. The floor is yours, Professor Yang. So good evening, everyone. It's really a great honor for me to be here and to be invited by the University of Hong Kong. I believe it's a very good platform, but because of the pandemic, I couldn't go to Hong Kong University in person. Otherwise, it would be better. And then my topic is quite broad, maybe. I will talk about the theme, as you can see on my slides, about the rights of the children born by the LGBT group. I'd like to share with you about my ideas from 3 aspects. First is about the legislation part. You know that strictly speaking, there's no relevant legislation about the rights and interests of LGBT people, but we mentioned about the topic. For example, in the amendment of the marriage law, a lot of people actually mentioned the legalization of the same-sex marriage, but the relevant authority at that time thought that it was not the time for our country to have the relevant law. But we can see that there are a lot of discussion in society about this topic. And in legislation, just few people have put up with this. And I'm actually an expert in the drafting of law of the NPC. After I proposed the relevant idea, it was not responded in a very active way. And about the cohabitation, also the relevant legislation party doesn't think it's a good time for us to consider the relevant rules and regulations. So in legislation, we are making some effort, but without very good results. Maybe it will still a long way for us to become a country like Netherlands, which recognize the rights and interests of same-sex couples. And for me, during the discussion, I thought that maybe we can talk about the rules and regulations about same-sex partners. Then we can talk about the same-sex marriage after same-sex partner is recognized or accepted by the society. But anyway, currently, the legislation authorities are not in support. And second, when we are talking about LGBT, about lesbian or gay, some people may wonder this is a kind of disease and they want to fix this kind of situation. Actually, several years ago, a court in Haidian district accepted a case. At that time, it was mentioned that in Chengdu, there's a clinic or an institution which provided treatment for gay or lesbian. And that LGBT guy went there to get the treatment. And then he collected evidence and filed a case to the court because the WHO has already made it clear that LGBT or lesbian or gay is not a disease, and you shouldn't try to fix this. And the Ministry of Health or the Ministry of Health and the Family Planning also mentioned that lesbian and gay is not a kind of disease, and there should be no treatment for this kind of situation. And during the judgment for that case, we have collected some advice, and we also wrote several articles so that we can have more protections for the gender minorities or the LGBT group. And the courts at that time claimed that this kind of treatment is a kind of tort of or the violation of human rights. But though it's a violation of rights, there will be no compensation. And as for the website which gave the advertisement for that institution was also not punished. So you can see that in this case, part of the judgment was quite advanced and part was still very conventional. And in our society, back in that time, the protection of the rights and interests of sex minorities is not a focus. And what I want to emphasize is the third part. It's about the children born with the relevant technology by the same-sex couple. What kind of parental relationship will they be in? Previous speaker mentioned that the ovum is from A and B is the one who gave birth to the baby and who should be defined as the mother. This is actually a problem. As the moderator said, my topic is to respect the dignity of children born with artificial assisted reproductive technology. And originally, I wanted to share with you about the children born by a surrogacy. How can we make sure that their dignity is respected from the moment they were born? So maybe I can talk about the surrogacy baby in the final part of my presentation. Here's a case in Xiamen, and in this case, the plaintiff and the defendant were two women. They lived together, and one provided the ovum, and they bought the sperm, and then they have the embryo transfer, and they got a baby. They actually reached some agreement or consensus, but later there are some issues, and they were fighting for the custody of the kid. And there's some dispute over who is the mother for the kid. And the one who gave birth to the baby actually hid the baby, and the one who provided the ovum actually went to court. And the court believed that in terms of the mother-child relationship, the principle is that the one who gave birth to the baby should be deemed as the mother of the baby. So the mother who provides the ovum is not deemed as the mother. So it's just the result of the first trial, and it was now during the second trial, and there's no conclusion up to now. I think that in this case, we need to consider several elements. First of all, no matter the children or the kid is born by surrogacy or was born by a same-sex couple, in mainland China, no matter the law recognizes the status or not, one thing is for sure. As long as the kid is born, his or her legal position or status should be recognized so that their dignity is respected and the kid will not be discriminated in his or her lifetime. This is the case in Xiamen, and also we have another case about the status of a kid born by a surrogacy in Shanghai. And in this case, the man and the woman were remarried to each other, and they were infertile, but they really wanted to have a kid, and they actually resort to surrogacy. And the husband provided the sperm. And they bought ovum from another male, another female, and then they entrusted a surrogacy, and the surrogated woman gave birth to a pigeon pair. But after that, the husband was died from a car accident, and the wife was supporting and bringing up the kids. But the parent-in-law or the parents of the husband actually mentioned that the wife didn't provide ovum, and she has no relationship with the kids, and they tried to get the custody of the pigeon pair from the mother, and they went to court. And according to the court, the judge believed that though the mother didn't provide ovum, nor got pregnancy, nor gave birth to the baby, still she should be deemed as a stepmother to the kids. But I have some doubts about the judgment, because the couple actually reached consensus to have the surrogacy. So this is born within the marriage. It shouldn't be deemed as a stepchild or stepchildren. If the pigeon pair were deemed as stepchildren, their dignity or their legal status would be changed, and their dignity would be like impaired. Though the stepchildren are entitled to the relevant rights and obligations from their parents, still I believe their positions or the legal status would be different, as they were deemed as a stepchild. So I believe that this kind of judgment about the legal position of children born in surrogacy would impair the status or the dignity. And the children born by same-sex couple, when we judge who is the mother, should also based on the biological relationship. When we are talking about these cases, we need to remember that in the 1990s, the Supreme Court once had the interpretation about a rule. It's about the legal status about children born with IVF or the artificial fertilization. If a husband is infertile and the couple gave birth to a kid through IVF, how should the parental relationship be defined? Actually, there are also three situations. First, the husband, the sperm is healthy, and he used his own sperm through IVF. Then there will be no distribution. And the other situation is that the sperm is not active enough, and it should be combined with other sperms to have artificial fertilization. Then the relationship of the kids with the father is not very clear. And the third, the husband is totally infertile, and the couple resort to a third party's sperm to give birth to a kid. And at that time, according to the judicial interpretation, it mentioned that after research, we believe that while a spousal relationship subsists, both parties agree to undergo artificial insemination, and the child born should be regarded as the legitimate child of the couple. So the rights and obligations between parents and child shall be governed by the relevant provisions of marriage law. I believe this is very reasonable. And I think this regulation could be applied to the kids born born in surrogacy, about their status, about their relationship with their parents. And also, when the wife had some problem and the couple resort to surrogacy, there are also 3 different cases or situations. We can also resort to the judicial interpretation of the Supreme Court to define the legal status of the children. Though we didn't have very clear rules and regulations in place, but we can resort to the judicial interpretation by the Supreme Court. So, as far as I am concerned, be it child born by a same-sex couple or born in surrogacy, when it comes to their legal status, we need to consider the several key points. First, it's about the Civil Code of China. In the Article 1002, it mentioned that we need to cherish the value of life dignity. And the life dignity is about the safety of life and the dignity of life. Now we are talking about the dignity of the children born with the relevant technology. And the life dignity in the past were not discussed a lot. But nowadays, we believe that life dignity is very substantial. So the dignity and safety of life should be protected, and the dignity includes the dignity of life and death. In the article wrote by me and my student, we mentioned that the dignity of death is of great importance for people. People is entitled to resorting to hospice. And they can resort to hospice care and other means to protect their dignity of death. And about the kids born in surrogacy and through the reproductive technology, we need to focus on the dignity of life. Because, you know, in terms of dignity of death, people can take the initiative, they can make the choice, but about the dignity of life, the kid has no ability at the very beginning to safeguard his or her own dignity. So it's up to the parents, it's up to the society to help them, to protect them. That's why we need to have the relevant rules and laws in place, and the institutions and the society should provide the help Otherwise, the dignity of life of these children would be impaired, and in their whole lifetime, they will bear the burden from their birth. This is not what we like to see in a civilized society. And the case I mentioned in Shanghai, the court deemed the kids born in surrogacy as stepchildren. I don't think they are showing respect for the dignity of life of those kids born in surrogacy. So no matter it's born from surrogacy or through artificial fertilization or born by the same-sex couple, in the recognition of their legal status, we have to make sure that their dignity of life is protected and guaranteed. And as Professor Boris from Netherlands mentioned, the principle in the recognition of the children born by the relevant technology is that it should be most conducive to safeguarding the interests of children. The children's interests should be maximized. That's the prerequisite. This should be the principle guiding us in the recognition of the legal status of children born with the artificial or assisted reproductive technology. So I want to reiterate again, the interests of children born by surrogacy or the artificial assisted reproductive technology should be protected and maximized. And in recognizing the legal status, it's not only from the technological view, we need to make sure that their dignity is respected. And in realizing this end, I believe that there will be three choices. First is like the case in Xiamen, which means that the woman who gave birth to the kid should be deemed as the mother. 20 or 30 years ago, maybe we didn't have the relevant technology to realize the reproduction. Then this principle has no problem. But now we have new technologies. We not only have IVF, but also have some surrogacy in other countries. Under such circumstances, the principle that the woman who gave birth to the kid should be deemed as mother will be controversial. And the second judgment base is that the mother-child relationship is determined by blood relationship. Means who provides the ovum should be deemed as the mother. Traditionally speaking, the principle that the woman who gave birth to the baby should be deemed as mother is actually the same as the principle based on who gave the ovum should be deemed as a mother, because several decades ago, technology was different, and the blood relationship and the delivery couldn't be separated. But now things have changed. And besides the blood relationship and childbirth relationship, I believe that we can have a third way. The one who make decision to have the IVF should be deemed as a mother or father. In the judicial interpretation, it mentioned that even though the kid has no blood relationship or biological relationship with the parents, yet the parents decided to have a kid during their marriage, then the kid would be deemed as a legalized kid during the marriage. And the case in Xiamen I mentioned resort to the principle of child delivery relationship. And the case in Shanghai resorted to the blood relationship, but both ways have some loops. So I believe that the third way, the parental children, will be the best. If we want to protect the dignity of these kids born by the technology, I believe that we need to resort to the third way, as I mentioned, in the parental children. And here I like also to say something about the children born by same-sex couple who resort to artificial assisted reproductive technology. For the lesbians, they can provide their own ovum and they can get pregnant by themselves. They can choose to get pregnancy and give birth to kids through the artificial assisted reproductive technology. But for a gay couple, things would be totally different, because they have to resort to others. What they can do is just provide a sperm. The ovum, the pregnancy and delivery are all done by others, because they have no abilities in this regard. And then things would be very complicated for the gay couple. Maybe in the short run, in our country, it's very difficult to legalize the same-sex couple or same-sex partners. Though the lesbians and gays are not legalized couple, they can resort to other means, like the story shared by Didi and the other speakers. They can actually go to other countries to have IVF and other ways to have their own kids. So though in China same-sex couple is not recognized or legalized, we have to recognize the legal status of kids born in surrogacy or through IVF by those same-sex couple. We need to make sure that their dignity of life is guaranteed and their interests are protected. As I mentioned before, the couple or the partner who decided to have the kid should be deemed as the parent of that kid. So we have talked about cases like A provides the ovum and B got pregnant and gave birth to the kid. And for the gay couple, they resorted to a third party or resorted to surrogates. No matter what the case is, as long as it's the couple's common decision to give birth to the kid should be deemed as their kid, and they should be deemed as the parents of the kid. Only by doing so can we protect the dignity of life and maximize the interests of those kids. And in their whole lifetime, their dignity will not be impaired because of the source of their birth. I believe this is the message I want to deliver today. I talked about the kids born with artificial assisted reproductive technology for normal couple and same-sex couple. So any dispute over the status of children born with the technology shouldn't impair their interests and rights and the dignity of their life. So Professor Yang, thank you for your excellent sharing. You actually reminded me of the time back in university when I attended your lecture. We can feel your passion and knowledge in the relevant field. And time is really limited. So I'd like to give floor to the teachers and professors. Whether do you have any question for Professor Yang? And Professor Yang talked about the topics about the legal status of the kids born with IVF and other technology. And the University of Hong Kong will have the relevant series of lectures and seminars. So if you are interested in the topic, you can actually fill in the questionnaire, and then we will send you the review of today's lecture and the information about the future lecture to you. So the lawyers and the professors and teachers attending today's meeting, if you have any question, you can raise your hand, or you can actually type your question in the chatting box, and I believe Professor Yang would be more than willing to answer. We have a question from a lawyer named Tiger. You can unmute yourself and raise the question. So if you couldn't make yourself heard, you can type your question in the chatting box. Thank you, Professor Yang, for your sharing. Can you hear me? Yeah, we can hear you. Thanks again, Professor Yang. Lawyer Zhao from Shijiazhuang. Can we actually write an article about your ideas and topics in our website or in our official account? After you write the article, you can send it to me for review. Do we have any other questions from other professors or teachers? Miss Luo, you can actually directly ask the question. So your name is Luo Ming, right? Yeah, it's me. Hi, Professor Yang. Maybe my question is not in closely relevant to your sharing. I believe your sharing is from the perspective of laws and rules, and my question maybe is more down to earth. Actually, when in the opening Didi shared her story, there's some dispute about the kids, and some would actually hide the kids. It's not just in Didi's case. I recently came across a case. One of the parents actually hide the kids before they have a final judgment from the court. So what would be the essence of the nature of this kind of practice? So I like to ask for your advice or experience in this regard. So actually, this kind of practice is not limited to the same-sex couple. Even for the normal couple, when they are fighting for the custody of kids, some of them will resort to hiding the kids. When I was still in the Supreme Court as a deputy team leader, I actually came across a case. The couple were in Beijing, and then they got divorced, and the wife actually brought the kids to Hebei province. And the couple actually reached an agreement that if one party got remarried again, the kid should be under the custody of the other party. And the wife actually got remarried, and she took away the kids. And the husband actually went to get back the kid. So hiding the kids or taking away the kid from the wife or the husband is quite common. If one party take away the kid by force, this kind of practice could be deemed as a tort action or as an infringement act. And for a same-sex couple, no matter how they gave birth to the kid, I don't agree with the judgments in the Xiamen case. The kid should be deemed as the kid of both the parents, and both the parents are entitled to custody. If one of them hides the kid and prevent the other from visiting the kid, it should also be deemed as a kind of infringement action. Some people may wonder that the couple is not legalized. How can their action be deemed as infringement? But actually, as long as the same married couple made a common decision to give birth to a kid, they are the first or second parent of that kid, as the professor from Netherlands mentioned. And they have the parental right. And if one actually prevents the other from visiting the kid, it's a violation of the parental right of the other. I believe we can solve this kind of practice. And the judge should be neutral enough in the judgment of such cases. So thank you, Professor Yang. Do we have any other question from other teachers and professors? If no question from professors, I'd like to ask a question from other audience. There are maybe 3 questions related to your topic. So, Professor Yang, the first question is about, you mentioned the couple made a decision. The decision should be made before or after the pregnancy or delivery. And second is if the surrogacy is also the ovum's provider and she changed her idea, she wants to keep the children by herself. So then what would be the situation? And also, do you believe that the parental rights of the same-sex couple would be more advancing than the protection of the same-sex marriage? And you mentioned that the interest of the kid should be maximized. Can this kind of principle be guaranteed? I think the answers to these questions will be very complicated. Maybe each can be expanded into a thesis. So I'd like to give you a brief answer from my experience. First is about the agreement or consensus made by the couple. No matter it's the gay couple or lesbian couple or a normal couple, when they decided to have a kid with artificial assisted reproductive technology, they have to reach this kind of consensus. And I believe the timeline should be before the pregnancy. First, they have the idea, they reach the common decision, then they will go to the practice to have the kid with artificial assisted reproductive technology. And if the couple didn't reach consensus and one resort to the surrogacy, the other was not on the table, then the problem would be quite complicated. So the timeline, I believe, should be before they went to the surrogacy. And the second problem, provide the ovum and do the surrogacy and want to keep the child by herself, it's actually not surrogacy again. It's a kid. It's just a kid born by herself. So I don't believe this would be a real case. This wouldn't be the case in surrogacy. Otherwise, the legal status, recognition of legal status of the children or the kid would be even more complicated. So we couldn't jump to a conclusion for the second question. And about the third question, So if the kid and the parent has no blood relationship, then will be there any parental right? I believe that we didn't have the relevant rules and regulations in marriage law, and there were some shortcomings in marriage law. The marriage law focuses more on marriage itself instead of the relationship. And the civil law in China, for a long time, didn't recognize such rights as conjugal right and so on. And in the amendment of the Civil Code, there are two articles or provisions. In the Code for Civil Rights, it mentioned about the civil rights based on marriage. The new amendment is actually about the identity rights or the rights of personal status. I believe that this is a great advance in the civil code or the civil law in China, because in the past we didn't talk about identity rights, but now we have very clear definition of the relevant interpretation about the identity rights. And the identity rights, as I mentioned, includes the parental rights and the conjugal rights and so on. And for the heterosex couple, things are not so complicated, but for the same-sex couple, their rights are not recognized. So I believe that the parental rights could be recognized before the conjugal rights. You know, for a single mother, she is, of course, entitled to the parental rights with her kid. And let's review the case in Xiamen. In that case, the court actually excluded the parental rights of the person who provided the ovum, which is unacceptable. So in that case, though they are a lesbian couple, after they give birth to a kid, we need to adhere to the principle of maximizing the interest of the kid, and the kid should be deemed as a kid of both of them, and both of the two ladies are entitled to the parental rights to that kid. And for a gay couple, and if the gay couple had a kid, one provided sperm, and they went to a third party for surrogacy. And can we say that the one who didn't provide the sperm is not entitled to parental rights? I don't think so. Both of the gay couple are entitled to the parental rights. So, you know, for one man, he provides sperm and bought an ovum and went to a third party to surrogacy. This man is also entitled to the parental right to the kid. I'm not sure if I answered the third question. I believe that the parental rights could be guaranteed. So thank you, Professor Yang, for your sharing. I believe you have answered the question very well. And now it's already 9:30. I think that we can have one last question. A student from the law school from a U.S. university. It means that the student actually got up very early in the morning. And he mentioned that you mentioned that you actually proposed the right to protect the LGBT or the sex minority, but it wasn't responded very actively. So what was the reason behind that? As I'm an expert in the drafting of relevant laws and I'm engaged in the drafting and amendment of civil code, I have my experience. And for the legislation or the amendment of the marriage and family, I've always put forward with the topic about same-sex marriage or same-sex couples' rights and interests. But in some official scenarios or in the process of legislation, it's not put forward very formally. I really want to facilitate the legislation of the relevant rules and regulations about same-sex couples. But the legislation authorities, they are not very active in this regard. So we didn't have the relevant judicial interpretation about same-sex marriage and couples in the marriage law. So I don't think it's a good time and scenario for us to dwell on the topic. So thank you for your answering. I hope that in the future we can have more comprehensive and in-depth discussion about this question.